brief introduction, my name is Sarah Carver. I'm with Alaska Legal Services as well. I help run a pro bono training academy, and we are soon expanding that to train non-attorney advocates that are interested in helping our various clients throughout the state. But what part of my job is to help run these webinars. And you're already either logged on or called in by phone, so that's a success so far. Just to give everybody kind of a logistical idea of what we're doing today. It was just mentioned some people are not able to log on online, so they're calling in via phone, and then they're going to follow along with a PowerPoint. So we have a phone and internet connection going at the same time, and we haven't done that very often, so we're a little bit concerned about feedback. So if you have the phone line open, or if your microphone is operational online, we just ask that you mute yourself unless you have a question. But we do encourage questions. So at any time, if a question pops in, feel free to interrupt David or myself. But if you don't have a question at the time, please just keep your phone muted so we can cut down on the background noise and the feedback. If you are logged in online and do want to ask a question instead of typing it in the chat box, you can connect your microphone, assuming you have one. To do that, there should be a phone icon or a microphone icon at the top of your screen, and you should be able to click on that, and it gives you the option to connect your audio. Everybody has microphone rights, so you can, if you have a microphone, you can go ahead and do that. And it should connect your microphone so you can ask a question directly to us. But if you don't want to talk to the group, you can always type your question into the chat box. Many people have already been using the chat box, which is great. We will monitor that throughout the presentation, so we'll try and keep track of anybody's questions that they type in through there. And of course, you can also call in to the conference line, which a few people have already done. So if you don't have a microphone, but you don't want to type into the chat box, you can use that conference code number. Okay, I see a bunch of people are signed in. Welcome everybody again. If you have any questions throughout the presentation, feel free to type it in the chat box or go ahead and unmute yourself. And with that, I'll turn it over to David.
Thanks, Sarah. So everybody, my name is David Panapinto. I'm a staff attorney with Alaska Legal Services down in Juneau. And today's webinar is going to cover tribal court family code development. And the goal of the webinar isn't so much to just give you some templates for you to fill out on your own. The idea is to raise some issues and some questions and some concerns that you might want to consider if you're going to draft your own family court code from scratch. And beginning with that, if anybody's following along on the phone without the internet connection, hopefully you have the PowerPoint. I'm going to follow it pretty closely, so it should be pretty clear when I'm switching slides. If it isn't, I'll indicate, something like next slide. But going to the first slide in the presentation, what I want to start with is sort of this overarching principle of the presentation that I'm going to come back to multiple times, and I think we should be thinking about this pretty constantly. It's about power within the tribe. Now, the power in the tribe, everything starts with the tribal members. And that's what I think is most important to keep in mind. And if those tribal members so choose, they can decide to write a constitution. And through that constitution, they can create and give powers to a tribal council. And that tribal council then has the power to create a tribal court or tribal court codes and ordinances. I've heard people in the past tell me that they were confused about the difference between codes and ordinances. Don't worry about it. They're basically the same thing. And I just want you to keep this in mind because as we talk about drafting a family code, the tribal members should be involved throughout the process because they're the ones who hold power within the tribe in the very beginning. So we're going to move on to the first step in creating a family code. And this begins with basically just figuring out if your tribal court, if you have one already set up, has a judicial code, a written judicial code. Now, it's not necessary, but I think it's helpful. And this sort of brings me to one of the second overarching principle, and this is about sovereignty. Um, as sovereign entities, your tribal government doesn't have to do things the way that a Western court model has done them. There's no requirement that you have a written judicial code. Sovereignty means it's less about following other people's rules as it is about creating your own rules and making this tribal court and the family code your own and making it unique. So you don't have to have a judicial code, but I think it's really helpful to have something written down. And certainly, if you have one, you should know it. You should start by going to the judicial code, reading it, and looking at your constitution, because there might be some limits placed on what you can do in your family code back in the judicial code or in your constitution, and you want to know that before you get started. So that's, in a very broad sense, the very first step that you want to consider when you're going forward with the judicial code. I'm just going to read the chat box for a moment. Sheila, good question. So if you're going back to the first slide here, if you're talking about where it starts, tribal members, I mean the members of the tribe themselves, the tribal citizens. Yeah, you're welcome. All right, so moving on from that, step 2, when you get past whether or not you have a judicial code, you want to start thinking about, hold on one second. There we go. You want to start thinking about who you want to involve when you're creating the family code itself, and you have a lot of options. A lot of what I'm going to talk about today are just recommendations. They're what I think are maybe best practices, but there's it's unlikely that there's a right or a wrong answer to the approach that you want to use. These are just what I think are the best practices. But some of your options about creating a family code, do you want it to be considered by the entire tribal council? Do you want to have them get together and draft the family code on their own? Or do you want to create some type of committee? Do you want to have it be made up of tribal council members as well as maybe some experts in the community and even outside experts if you wanted to include them as well? You can have a group approach. Or do you want to directly involve the community itself as a whole? The reason I bring this up, and it goes back to power within the tribe, is that code drafting can really be used as a way for the community to define and understand its culture, but only if they're directly involved. I think this is where it's going to come in multiple times during the presentation, that you can make your family code or your tribal court really meet the needs of the community if you involve them throughout the process. So those are some options. As a tribe, you'll have to figure out what makes the most sense for your community. Going to the next slide, we're still within the second step, and another one of these initial considerations you're going to want to look at is what type of law do you want your tribal court judges to consider when they're looking at these family cases. And basically, we're talking about two types of law. There's written law and there's unwritten law. Written law is exactly what it sounds like. It's the Western model where a law is written down, it's static, and unless it's amended, it doesn't really change. So you're putting a law on the books, so to speak. Unwritten law is much different and much more exciting in some ways. A great example of that would be, advice of elders. So do you want your tribal court judges to be able to receive the advice of elders that's maybe not written down when deciding their family court cases? And again, this comes back to sovereignty. This is, for me, the most exciting part about tribal courts is that the tribe gets to do things in its own way, in the way that works best for them. So really take charge of the process and make it your own. And you can't really answer this question, in my opinion, without figuring out what the tribal members themselves want, the tribal citizens. Get them involved and figure out how they want the court to function, because that's how you're going to get them invested in the process so that they'll support what you're doing with the tribal court. Going to the next slide, this is an example. I'm going to include a lot of samples in this presentation that I hope are helpful. This one comes from the Sitka Children's Code. And I think this is a great example because it lays out in very clear terms something that isn't very clear in itself. So if you look at section B, the Sitka tribe has declared that a tribal court judge can use traditional Tlingit law in cases where traditional Tlingit law would be beneficial to the child's case. Then in Part C, they define what unwritten law means, what this traditional law is made up of. And they say that the tribal court judges can rely on written or recorded accounts of traditional Tlingit life. They can interview elders or cultural bearers, or they can call upon various committees to give them advice. This is important if you're going to write a family code and you want to use unwritten law, this traditional knowledge. I think it's important to write that down and include it so that people know what meets that definition, what they can rely on, so that they have freedom to go outside of the box and not just use a Western court model of witnesses and written evidence and laws on the book. Okay, before we go to step number 3, the next slide, I'll just pause for a couple of seconds. Does anybody have any questions so far? Okay, hearing none and not seeing anybody typing, I'm going to keep moving forward. Step number 3 is about the authority to hear a case. And what we're going to be talking about here is jurisdiction. Now, this is a term that you might hear thrown around a lot in courts and by lawyers, and it's confusing. Admittedly, you spent a lot of time in law school studying this to figure out exactly what it means, but basically, jurisdiction is the court's authority to hear a particular case. And it's made up of 2 different kinds of jurisdiction. The first one, people often refer to as personal jurisdiction. And you want to decide when you're writing your family code what authority the court has to hear different types of cases. It starts with personal jurisdiction, and that means who is the court allowed to hear? That means who is allowed to go to the court and ask for help to set up a court case because they want something resolved in the tribal court. They're actually going out and seeking the assistance of the court. But it also means who is the court going to be able to drag before the court sort of against their will? If somebody has a case filed against them, who is the court allowed to bring if they don't want to get involved, if they're not consenting and agreeing to it? So that's the first type of jurisdiction. The second type of jurisdiction is more important to what we're going to talk about today, and it's called subject matter jurisdiction. This is, the meaning is right in the name, subject matter. What kind of issues can the court hear or consider? And this is really important when you're drafting your family code so that you can figure out, if you think about it, I can think of at least 12 different issues that a family court would be able to consider. And you need to give your court authority to hear those, or maybe tell the court that it can't hear those different types of issues. Moving on to the next slide, I'm not going to focus on personal jurisdiction because if you have a written judicial code, if you already have a tribal court, that's probably already in there. You probably already have rules about what people can use your court. But what about subject matter jurisdiction? Within your family code, your family code, you might address things like custody between the parents, adoptions, divorce, guardianships over children, and even domestic violence. And there's more than just that. Those are just some of the most frequent, the most important ones that get dealt with by tribal courts. And you got to figure out what's appropriate in your community. Going on to the next slide, you want to figure out what the tribal members and what the tribe itself wants to resolve through their tribal court. And you can't do that without involving the tribal members. And I'm going to come back to this multiple times, but you really want to get their input. You want to get their advice about what types of cases they think are appropriate to handle in your tribal court. This is just a personal recommendation, but in my opinion, I would say don't add one of those issues or one of those topics into your family code unless you really want it and you feel like it's really needed at the moment. I think it's probably a good idea to start small and then expand. And what I mean by that is instead of writing your family code and having it be, 100 pages long, covering every issue that could possibly come under the umbrella of family law, what I would say is choose a handful of the most important issues, start with those, and then when your tribal court judges feel comfortable and they're efficient and they're doing a good job handling the cases that they're authorized to handle, that small group, then maybe go back and look at your family code again and add a couple more topics. Don't make the mistake of biting off more than you can chew at the very beginning. So start small and then grow. We're going to move on to the next slide, which is going to be the start of step number 4. And this is what I've called the statement of purpose. All that means is typically if you look at court codes, at the very beginning, there will often be a short explanation of why and how the tribe wants to address a particular issue, why it's important to the tribe, and what factors the court should be considering when it's handling these types of cases. Again, this is just a recommendation. It's a best practice, but it's not required. It's a good practice because it provides guidance for a bunch of different people that are involved. Most importantly, it provides guidance to judges. I don't think you ever want to make a judge guess about what they should be considering and how they should reach a decision. So for example, if you write a family code to include custody between parents, you want the judge to be able to look at your statement of purpose, and it can provide guidance and insight for what is important in those cases, what that judge should be considering. And I've got some examples here that hopefully will bring this to light. Going to the next slide, which is a sample from Tanana Chiefs Conference. I would highly recommend that if you're going through this process of writing a family code or any kind of code for that example, look online at some of the examples, the templates you can find, and TCC have fantastic templates on their website. So go check those out. If you have internet issues, you could probably call them and they'll mail you a copy. But here in their general template, they provide 2 paragraphs as a statement of purpose for their sample domestic relations code. When I look at this as a lawyer, I actually think that it's pretty short, and there's not a lot there in terms of length. But if you break it down, as I did in the highlights in the next slide, you can see that they're providing a ton of guidance to their tribal court judges just in these 4 short paragraphs. So by including this statement of purpose, any tribal court judge who's going to handle one of these cases automatically knows that the tribal court is focused on the health, safety, and welfare of the tribal citizens, that its goal is to preserve and strengthen family ties, that it should protect and preserve tribal heritage and cultural identity, and it should promote cooperation with the tribe by other courts and agencies. Then going to the second paragraph, it also says that the most valuable resource of the tribe are the people itself, and that a big part of that is the welfare of children. And the tribal court should focus on creating healthy, content, and productive members of the tribe and society in general. So just in those two paragraphs, whoever would adopt this tribal code would be giving guidance to the court about all of these things they should be considering when they're involved in these admittedly pretty messy and challenging family court cases like custody cases. Another example, and I use this one to show that there's no right or wrong way to do this process, is from Tlingit and Haida in Juneau. Now, for their children and family code, under the marriage section, they have written a short and sweet statement of purpose that just says that the purpose is to govern the process of permitting and conducting marriages, divorce, and establishing custody arrangements. Now, that's very different from the one before, but it also provides quite a bit of guidance. It lets you know that in this section, if you're going to file a court case that is relevant to the family code, it's only going to be dealing with marriages, divorce, and custody. And so the judges that are using this code know what they're limited to do. So I think even though this is a very different approach, it's extremely helpful to have this information provided to the members of the court. Now, step 5 is about definitions on the next slide. I'm going to pause here for another moment or two and see if anybody has any questions. So I'll just see if anybody's typing in the box, or if you have something, just feel free to speak out. Okay, hearing no questions and seeing nobody typing in the box, this is a step that I think is particularly important. So after you have, figured out what types of law, thought about your jurisdiction, and written a statement of purpose if you decide, I think you want to start thinking, even before you write your code, about definitions. You can't know what the code allows somebody to do, whether that's a judge or whether that's a person involved in a court case, without knowing what terms are defined by the code. We don't know what it allows unless all of the important words in that code are defined. And that's because words matter. This is particularly important to me as an attorney because that is what we do for a job most of the time, is argue about the meaning of words. And you have the power when you're writing your family code to sort of short circuit that and tell people what the words mean so that there's no arguing over it. This was the first piece of advice that I got as a young attorney, that words matter, and it's something that I have carried with me for the past 10 years. Going on to the next slide, what I recommend you do is, when you're doing your family code, define every single word that you think a reasonable person might disagree on, and then go back and define some more of them. Unless the section of your code that deals with definitions is longer than your code itself, I don't think you can define too many terms. I think it's always helpful to have a clear definition of what a word means in your family code. And this would typically come directly after your statement of purpose. You would have a list of definitions. And my recommendation is to do this because even if the meaning of a word is easily understood by most people in your community, you should write your code as if it applies to people outside the community, because meaning changes depending on what culture a person is involved in or what community a person is involved in. Going to the next slide, one of the major reasons why we do this is that definitions help the judges understand what types of cases they can accept in the first place, and it also helps them understand the factors that they need to consider when making a decision. We'll get into this a little bit later, but by including a definition and telling the judge what he or she needs to consider, you are making sure that they follow the rules that the tribe wants followed in the very first instance. And I think that's incredibly important. But almost more importantly than the judges is how it affects the parties to a case. It helps to ensure that the parties are involved in a fair process. If two people are involved in a messy custody case in your tribal court, and they start arguing over what the term family member means, you can short circuit that fight by, if you've defined that term in your written family code, by just pointing to the code and telling them exactly what it means. And that helps to ensure that you have consistency and reliability so that people involved in your court as parties know that they've been treated fairly and that the next person to come in is going to be treated the same way as they were, so that everything is the same each time. And this just goes to making sure that people trust your court and trust the way that they're going to be treated. Okay, so staying within step 5 on the next slide, these are some terms that I think are helpful to define, even though some of them seem really simple and obvious. We all know intuitively what a child is, but legally, you want to define that. What does it mean in terms of age? What does it mean in terms of their tribal affiliation? Are they considered a child under your code if they're from a different tribe? Adult is another one that seems simple, but you want to define who has access as an adult under your code. Family members are huge. I have an example of this in a slide that's going to come next. Especially with child welfare or custody cases, two different people, even in connected communities, might have very different definitions of what it means to be a family member. And you can solve problems before they start by defining what that means. And it also gives you broader power if you want to have a very broad definition of family. For child welfare cases, if you choose to tackle this topic in your family code, there's a bunch of definitions that I think best practice you want to include. What does abuse mean? Does it include emotional or mental abuse or just physical abuse? If you don't write down a definition, people won't know. What does neglect mean? What does it mean to abandon a child? And then for custody cases in particular, we'll go into a deeper discussion in a minute or so with an example slide that I'm going to provide, but what does it mean when a court has to consider the best interests of the child? If you just use that term and don't define it, it'll be a mystery and there'll be a lot of insecurity and confusion about that. So now we're going to get to some of these examples, and this is another one from Tlingit, Haida, and Juneau, and I love this definition that they provide for extended family. One of the things I like most about it is at the very beginning, you see the first sentence says, this term, extended family, does not have a precise definition. It's something that is kind of fluid and it's hard to define. It's hard to just write a sentence and tell somebody what it means to be a family member within the Tlingit Haida tribe. And they admit that at the very beginning. I think that's a great starting point. Then they go through and they talk about what it means to be a family member based on blood or marriage or friendship. They have this line that says that all women in the community become auntie or grandma when they become a certain age, regardless of their relationship to people based on blood. And then they say that beyond just aunts, uncles, siblings, cousins, in-laws, and step relations, any member of the Tlingit Haida community who is reliable, responsible, loving, and willing to care for a child may be considered extended family. So this is an extremely broad definition of family. It basically includes anybody in the tribe who wants to be considered family, anybody within the community. And if you didn't define this term, it would be difficult in a court case, in your tribal court, to do this on a case-by-case basis. This way, everybody knows what it means to be an extended family member, and people know they can be included in cases as family members, even if they don't meet a traditional Western sense of what family means. Going to the next slide, this is also from Tlingit Haida out of Juneau. Here they define what it means to be an Indian child. So the first line there is pretty straightforward. They just say that a child is any unmarried person under the age of 18. And I think we could all agree on that. That's a simple definition. But they want to extend the powers of their family code beyond what you would typically imagine in a state court. So here they say that an Indian child is not just a member of the Tlingit Haida tribe, but it's any member of a federally recognized Indian tribe, anybody who's eligible for membership in a tribe, the child or grandchild of a tribal member, somebody who's eligible or a member of a Canadian band, and then lastly, anybody who's considered to be Indian by himself or herself and by the Tlingit and Haida community where they reside. So children are not limited here to just the members of the Tlingit Haida tribe. It's to any Indian child. Any Indian child can be involved in a court case under certain circumstances in the Tlingit Haida tribal court. So that really broadens their authority to hear cases, who they're allowed to bring in front of the court. And your tribe might decide that you want to limit it only to tribal members of your particular tribe. And that's fantastic. That's great. That's what works for your community. But again, this is what sovereignty is about. The unique thing is that every tribal court in Alaska can and sort of should be completely different because it's going to meet the needs of the community. So they should be unique. And you'll have to figure out how you want to define these terms, because it'll have a huge impact on your cases. Going to one more definition slide, an example. This is from Kanaitsi, from their domestic relations code. And here they define what it means to consider the best interests of the child. Most state court systems, when a judge is considering who to place a child with in a custody case, the judge is given a list of factors that they have to consider. And we do this because we don't want a judge to just look at the father or the mother and say, yeah, they look like good people, so let's give custody to the mother. You want it, it's such an important decision about who that child is going to stay with that you want the judge to consider at a minimum certain factors. I won't go through all of these. You can go back and read them on your own later, but there's 8 factors, things like the basic needs of the child, whether there's been any evidence of violence, whether the parents are allowing the child to have a loving relationship with each other. These are the factors that at a bare minimum, the Kanaitsi tribe wants all of their tribal justices to think about and to consider before granting custody. Now, if you look at number 8 says, as well, any other thing the court feels is relevant to the best interest of the child. It's this catch-all provision that gives the court freedom to consider anything else that they feel is important in that particular case. Don't be afraid to use this kind of language in your family code, because you want to make sure that your tribal justices are doing the minimum, but give them the freedom to consider other things as well. Don't limit them to the minimum. Let them go beyond that by including this definition of, yeah, you can consider anything else after you're done considering these 7 other factors. Okay, again, I'm going to pause for a moment or two before we go on to step 6 to see if anybody has any questions. Okay, thank you, Sheila. And like I said, please feel free to interrupt if you have a question while I'm talking. But we're going to go on now to the next slide. This is step 6, which is procedures. This is the meat and potatoes of a family code, or any code really for that matter, that you're going to create for your tribal court. You want clear procedures because about how things are going to be done in your courtroom. First, because it informs the judges the rules that they have to follow. Like I said before, you don't want your judges guessing. Right when you're doing this, the benefit of writing a written code is that the judges or the court clerks can look at the code and say, oh, this is a petition, and these are the rules for writing a petition that is set out in our family code. So the judge knows what he or she needs to look for. Also, it informs the parties themselves, the people that are involved in the court case, what rules they have to follow, and also what they have to prove. So if somebody wants to start a custody case, it's really helpful for them to be able to go to the court and for the clerk to tell them, here, look at our family code. This is what you have to prove, and this is the process you have to go through in order to get custody of your child through our court. I would say almost most importantly is having clear procedures. Make sure that everybody who goes into your court is treated the same. We're going to talk about this in a few moments with the idea of due process, but you want your tribal members or anybody involved in your court to know that they're treated the same as anybody else. If the procedure or the process changes depending on who is before the court, that's going to cause problems, and it's going to create a lot of distrust within the community because people want to know that they're getting treated the same and that it's equal and that it's fair. So this is why you want to have really clear procedures so there's no confusion about it. Going to the next slide, again, this is best practice. These are recommendations, not requirements. But if you're going to have procedures in your family code, I think you should have clear guidelines for the following. First of all, petitions. Petitions are, typically speaking, just a short written document that somebody files with the court asking for permission to open a case. And it provides information about who's involved, what the court case is about, and why the court should grant them the relief that they're asking for, like a custody order or a domestic violence protection order. It's the information the court needs to get started, and you can, in your family code, provide a list of what information that needs to include. Also, notice. Notice is some type of information provided to the parties so that they know that a court case exists, and also so that they know about the court dates, when they have to show up to the tribal court, so that they have the opportunity to be heard. And there's rules, you can provide rules for how that notice has to be sent out, if it has to be mailed, if it has to be provided in person. You're given the opportunity when writing your family code to create those rules and set those guidelines for how it's supposed to be done. Also, extremely important with hearings. You can choose what cases get hearings. Hearings are when you go in front of the judge and you actually get to argue your case. You can choose what types of cases get hearings, how they get hearings, and how the hearings work, what types of evidence are allowed at those hearings. Orders are just the final decision that a judge issues at the end, like a custody order saying one parent gets custody and the other gets visitation. And then legal standards. It's helpful to write into the code what standard the parties need to meet to prove their case. So what does a person have to present to the court to prove in order to get a protective order for domestic violence. Now, I'm not going to spend too much time on the topic of due process. This is the next slide, because I think this is something that theoretically could be a whole separate webinar. And if anybody's interested in that or in any other topics, please send me an email, and this is something I can look into doing. But due process is a legal term, and basically it really just means fairness. It's fundamental fairness. And the reason we're going to talk about it is because even though your tribal government and your tribal court is sovereign, the state and the federal government still do have a little bit of power to make sure that people involved in court cases in your tribal court are treated fairly. And if they believe that the people are not treated fairly, that they didn't receive due process, they can wipe out the order that you issued or start a state court case that will just redo everything. And nobody wants that. Not the tribal court, not the people involved that have already received an order from your court. So this is really important. Due process is made up of three things, basically. Everybody needs to receive adequate notice. So what that means is that if somebody is going to be involved in a court case in your tribal court, they need to receive some notice that the court case exists, and they need to be given the opportunity to be heard at the court hearings that are going to be held. It doesn't mean they have to show up. It just means they have to know about it so they can make the choice of whether or not to show there. It also includes the opportunity to be heard. So what this means is that your family code should set out something in writing that establishes how a person is able to plead their case before the tribal court justices. You don't have to follow a Western court model. This is, again, what sovereignty is about. You don't have to allow attorneys into your courtrooms. You don't have to do things the way that they're done in state court, but you need to make sure that people that are subject to your jurisdiction get a chance to tell the court why they agree or they disagree, and let them give reasons for why the court should decide in their favor. There also has to be a fair tribunal. You should have something written down in your code, if you're going to draft one, about what I would call recusal. Basically, an example of this would be, imagine you have a messy custody case, and you have two parents fighting over custody of a child. If the tribal court judge is the father of the biological mother, and he's making the decision about where that child is going to stay, that doesn't look very good. Even if he's able to make an impartial decision, it has the appearance of partiality, and that could violate due process. So you want to have rules about conflicts of interest and when judges that are too connected to the cases need to step back and let somebody else handle it. We're going to go through a handful of examples here, and I might go through pretty quickly, but these are examples of procedures. The first one here is again from TCC. It's from their Sample Domestic Relations Code. And I'll let you look at this on your own time, but this is a great example of defining and providing a clear procedure for a child custody petition. So we said that a petition is this written document that you file with the court asking for the court's assistance. But here, they provide 6 things that have to be included in order for the court to open a case. This makes sure that the court understands what they need to get started, and it helps the parties, the person requesting help, understand what they need to include to get started as well. You need to include the name, the address, and the age of the child, the names and address of the child's parents and any custodians, the names and addresses of any other person or tribe with a specific interest in the child, and then 4 and 5 are related. The person filing the petition needs to state the reason why they're requesting custody of the child, and then provide the facts which support why that's in the best interests of the child. And then 6, a statement of which tribe the child is a member of or affiliated with. This is a fantastic, very short, very sweet list of how to start a case for child custody if you're following the TCC model. Going to the next slide, I'll go a little quicker with this one. This is from Knightsey, and here they're talking about temporary custody hearings after the tribe has taken custody and control over a child in a child welfare case. They cover a lot of ground here, so spend some time on your own and look at these factors. They look at when a hearing has to be held. They say that a hearing has to happen within 30 days for temporary custody. They talk about where notice comes from. They say the court itself has to issue notice to the parents and the guardians. It talks about due process concerns. So Section B, if somebody is given notice of the court case and they decide not to show up, their domestic relations code gives authority to the judges to just move on without them. That doesn't violate fairness or due process because they know about the case and they're just choosing not to be there. And then, very important, C, it lists the witnesses, the rules for witnesses. It says that at the hearing, you can call witnesses, you can question the other person's witnesses, and the judges can question witnesses as well. This is, at the hearing, how the person succeeds and what evidence they're allowed to provide. The last one here, again, I'll leave this to your review. This is from Plinkett Haida out of Juneau again. They set out rules here for a change of custody. And this, again, touches upon the hearings, the requirement of a hearing. It touches on notice, and it provides a definition for when somebody is entitled to request a change of custody in the first place. So if that's something that you're thinking about doing with your family code, go back on your own and look at this one in a little more detail because it's got some good information there. Okay, we've got a couple more steps. I heard a beep. Is somebody trying to ask a question? Okay, I'm going to keep moving. We just have, I believe, 2 more steps. And these ones are pretty short and sweet. Step number 7, just consider confidentiality. Consider the need for privacy in sensitive areas. When you're writing your family code, think about what types of cases you want to be confidential. A lot of these cases are going to involve children, and these are the issues that you might want to consider keeping your court records confidential, which means that nobody is allowed to come in, no member of the public is allowed to come in and get copies of them. That's because we don't want people knowing the business of these kids when they're involved in these kind of complicated matters. So just if you're dealing with child welfare cases or adoptions, and there's other topics as well that you might want to keep confidential, consider how you want to handle those records. And you can write that directly into your code. Step number 8, speaking of child welfare, again, I'm not going to go into too much detail about this because it could be a separate webinar. But if you are going to handle child welfare cases in your court, these are some of the basics you should be thinking about for your code. Tribes have exclusive jurisdiction over a child welfare case if the child has been made a ward of the tribal court. What that means is if the tribal court or the tribe has stepped in and taken custody and responsibility for a child because something is going wrong in that home, that tribe has the sole power to start a court case about that welfare. Not the state. If the child is a ward of the court in the tribe's custody, the tribe itself has exclusive authority to hear that case. However, if the tribe has not taken custody and control over that child, if there's just something going on in the home and everybody recognizes there has to be a welfare case opened, there's overlapping jurisdiction. That means that either the state or the tribe can start a case. Generally speaking, what happens is whoever starts the child welfare case will end up keeping it. If the state is the first to initiate a case, a China case, OCS gets involved, then it'll most likely stay in the state court. If the tribe starts it and they proceed in the tribal court, it'll most likely stay with the tribe. I noticed that there were a lot of email addresses related to ICWA workers, so anybody who's an ICWA worker knows that the exception is that the tribe has a right to intervene or to request transfer from the state court under certain circumstances. The reason I bring all of this up is again to talk about sovereignty. So on the next slide here, I want to stress that ICWA rules, the Indian Child Welfare Act, they don't apply in tribal courts. The tribe creates its own rules and its own protections. ICWA rules only apply in state court. So exercise sovereignty. If you're going to handle child welfare cases in your family code, if you're going to write that in, you have the power to write in the protections that you want to see, and they can be different from the way the state court runs the show. I have a couple of final thoughts, and then I'll just open it up for blanket questions or comments that anybody might have. The first one is when you're writing your family code, or any code really, avoid legal speak. Don't try to sound like a lawyer. Even as a lawyer myself, I get really frustrated when I get letters or I see written documents from other attorneys that sound way more complicated than they need to be. If you've ever tried to read, for example, your GCI cell phone contract, even after 3 years of law school and 7 years practicing as an attorney, I have a hard time figuring out what that means. When you're writing your family code, write it for the people in the community. Don't use words that are too complicated that people that don't have a legal background won't understand the meaning of. Use everyday language so that the members in your community, the tribal members themselves, can know what powers the court has and know how to take advantage of the court when they need to. And this one is a little tricky. I put in here avoid templates. Now, as I said before, I think templates can be really great at the beginning of this process when you're starting to write a code from scratch, because it can be really intimidating if you have never written a code before, if you don't have a background in it, to start from nothing. So I think it's great to go and look at TCC or Tlingit Haida or Kanaitse. There's a lot of tribes that have codes available online. Look at them for inspiration to get started. But then what I don't recommend doing is just finding a code online, crossing out the tribe's name, writing your name on top, and then adopting it through your tribal council. That's not good for your tribal members because it's not unique to them. It's not something that fits their needs. It was written for a different people, and I would recommend, doing this from scratch so you have a unique, one-of-a-kind tribal code to deal with family issues in your community. Also, publicize. I've said this multiple times, and I just really want to drill it home that I think it's the best practice to really involve your tribal members. And that can be anything from sending out copies of your draft family code so they can give input, or something as simple as holding a potluck or a community meeting where tribal members can come in and speak freely and tell you what they want the tribal court to handle and how they want it to operate. It builds trust, it builds internal investment in the tribal court model, and I think it will help in the long run to make sure that the tribal court has the support of the community. And then lastly, you want to go back and you want to amend and review your code periodically. You don't have to do it every year, but I put this in there because there are some tribes who adopted codes in the 70s and they've never been changed. And if you wrote a code in the 70s, chances are your community is very different now than it was 40 years ago. So you want to go back and you want to amend it. There's nothing wrong with changing, adding, or deleting something from your code to make it a living document, to make it relevant to what's going on in your community now, and to make sure that the most important issues in your community are being addressed. So I want to thank everybody for participating. If you have any questions now, please speak up, let me know. And if not, you have my email address and my phone number. Feel free to reach out to me if you have questions about this presentation or if you have recommendations for issues that you'd like further webinars on.
Hi, this is Anthony Gaston, the Tribal Course Coordinator out of Cake, Alaska for the Organized Village of Cake.
Hi, Anthony. How are you doing today?
I'm doing fine. And one of the questions that I had is that because we're just starting our tribal court, so, we do have our codes already, and they are going to be amended because they were done a while back. Mm-hmm. And one of the things that I wanted to know, what is the best procedure to approach council with learning about the due process and also the conflict of interest? Because I feel that that's one of the things that we need to really educate council and other members. That's going to be part of our pool of judges on the importance of that.
Absolutely, and great question. I'm glad you brought that up because I do think that if you're going to go through this process, that is something you should directly address, both of those issues. And honestly, I think the best answer I can give you is that if you want to reach out to me through email, maybe that's something that we'll have to look into it, see if that's something that Alaska Legal Services would be able to provide, some type of training on those two issues.
Yeah, that's one of the things that I really want to make sure that we educate ourselves and approach the council in a diplomatic manner where nobody's offended whatsoever, and also an invitation for everyone to have these work sessions where we can work together.
Absolutely, and I think you bring up great points. You want to have these conversations are difficult. Nobody wants to be told that they're too connected to a case, and even if they feel they can be impartial, nobody wants to be told they have to step aside. So I think it's great that you're thinking about it in terms of being inclusive and being sensitive to those feelings, but also recognizing how important it is. So yeah, please send me an email and we can talk about that in more detail.
Okay, I sure will. But thank you so much for your presentation.
Oh, no problem. Thanks for participating. Is there anybody else out there who has any questions or any concerns?
No concerns. This is Muriel in Antioch. I would like to be included on any future webinars you have.
Absolutely. So I kept a list of everybody that I invited to this webinar. So yeah, please be confident that if there's another one, you'll certainly get one of those emails as well.
Okay, thank you.
You're welcome. All right, I see a couple of people typing. The webinar was supposed to go till about 2. I'll stick around for as long as anybody is interested to answer questions. Okay, yeah, and I'll just echo Amanda's comments here. If you have any questions or if there's anything additionally that you need please reach out through email. I'm always happy to see if there's anything more we can do.
On that, I
Thank you
just
very
want to
much.
Thank you.
remind everybody that this
Okay,
is
bye-bye.
recorded, so we will send a link to the recording
Thank you.
hopefully by tomorrow. So if you had to cut out, or if you missed a little bit, or if you want to share it with other people in your area, please feel free to do so. We will make sure to stay in touch. And as David mentioned with Anthony's question, if your tribe feels like you want some help talking through code drafting, specifically with Alaska Legal Services, that is something that we're interested in helping with. So please feel free to reach out to David or I or the attorney in your local hub Alaska Legal Services office. So that's something that we are interested in walking through with you, or we can provide trainings as well. So we will be in touch, and we will also make sure that everybody here is a member of the list for any future webinars that we can conduct on these topics. So I'm not seeing any other questions, David. Are you seeing anything?
No, just some thank yous, and yeah, thank you everybody
Awesome.
for
Well, with that, I will
participating,
end the
and
webinar. So this window will close, but
I think
again,
that's
you
about all I
have our
got.
emails, so please feel free to use those. All right, everybody, have a great afternoon.